Welcome back to another episode of Law Schoolers. In this episode, we are talking about recurring searches of inventory. This should be a brief one. Inventory searches are pretty straightforward. What it is pretty much when officers detain people, they oftentimes take personal property into custody and they store it for safekeeping, and this process can also produce criminal evidence. Well, why do officers do an inventory search in the first place? Well, they don't want to be held liable for any claims that the subject might have. Say the subject is released, they get their items back. They don't want to claim that something is missing and then the officer has to cover the cost of that thing, even if that claim is an untruthful claim. So an inventory search is simply to protect the officers from liability from any potential fraudulent claims that the subjects might have. By taking inventory, they just write down every item that has been taken, and if there's a fraudulent claim, say, nope, look at that, we have it right here, this is the condition it was in, or it was missing, that kind of stuff. So the officers are able to protect themselves. So, what happened in People v. Gibson? This is our one case. Well, our rule is that officers are free to conduct warrantless searches of inventory in accordance with any inventory search policies. These policies can still be pretty broad, and even though they're broad, they can still be constitutional. An inventory search is going to be an exception to the warrant requirement where the officer conducts the inventory of the contents for the purposes of administration, protecting themselves, ensuring that what's gathered is fine. Now, how do you conduct an inventory search? A proper inventory search. Well, the state needs to show that a policy exists for the inventory search. This policy can be broad. There needs to be a valid impoundment and procedure. And then third is that the purpose is done for inventory and not as a pretext to look for crimes. Remember when we talked about a pretextual stop? And pretextual stop, you have reasonable suspicion for the stop, but you're looking for something else. Can't do that here. You can't detain somebody and say we're doing an inventory search, and in fact you're looking for something other than inventory. Essentially, the search can be challenged if there are no procedures. This is going to follow the Wells rule. Or if the purpose is inappropriate. Again, if the purpose is pretext, looking for crime instead of anything else. That's going to be Burton or Burton. And that's inventory. Really straightforward, simple stuff. But essentially, the purpose is to protect the officers. And as long as you have a valid procedure, valid impoundment, a valid policy, and the search isn't done in a pretext, you're good to go. That's everything for this episode. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.